No, not too Hollywood, Anderson. You have to have a certain level of accuracy and recreation of the actual conditions. So as was pointed out in some of the questioning, it wasn't raining. It wasn't nighttime. You didn't have certain other physical pieces of evidence in your scene that were present at the time. In order to make this relevant and in order to make it more probative than prejudicial, as we say in the law, you have to show that kind of accuracy, and he doesn't have it. I'm surprised he's never been refused admission of this kind of reenactment before, but it may be because he has not offered it in a criminal case before. In a criminal case, the standard is pretty high, and I don't think he's going to make it.
Danny, you think that's the case? He hasn't done it in a criminal case? Because I mean, in this video, you see Trayvon Martin hitting George Zimmerman first. That's George Zimmerman's side of the story.
Exactly. What they're trying to do is admit this as substantive evidence, so it has to meet a much higher bar. Now, we can talk about Iron Man suits and video games, and I would agree that if these two parties, Trayvon and Zimmerman, had been wearing these suits at the time of the incident, then I think this would probably be an admissible video. But that's the problem. It's the underlying data that's being fed into this supercomputer. What is that data? Well, it's based on statements. I mean, the data coming in is probably questionable. That's really what the prosecution's argument is. I mean, if it was merely just a demonstrative exhibit, the standard is much lower. But overall, I mean, yeah, the science is good, the technology is good, but that's only good for Iron Man. It's not good if the underlying data doesn't support or demonstrate accurately what happened.
Are you surprised, Mark, that it has gotten this far in terms of the judge giving so much, to each side to discuss this, and now she's going to wait till tomorrow to rule on this?
No, not at all. I agree, I hate to sound like an echo chamber here, but my guess is, and I'm sure I'll get an email from this gentleman tonight, but my guess is that he's always had one of these in a civil case where you're fighting over money. And this is not a civil case, obviously. Having said that, I've seen, and I've actually been on the receiving end in the LA County DA's office, where they've had some not quite animated, but in murder cases where they've had somebody throwing, for instance, a watermelon in their backyard to try to demonstrate how the murder took place. And that has been admissible. I think the reason the judge actually is struggling with this is there is a good or some case law which would suggest that when the defense has a theory and they've got a recreation of it, that they can get that in. And the problem is how they've recreated it here, and I think that's what she's struggling with. I think Her Honor is struggling with the idea of, well, even if he's basing it on what George Zimmerman's account is the way that they've done it true to it, like a hypothetical question, so to speak, or is this really taking some liberties? And she doesn't want to be in a position where, in the unlikely event that they get a conviction, that this goes up on appeal and some justice on the Court of Appeal rules, hey, you should have let that in. That was an important piece of defense evidence, and therefore we're going to reverse this unlikely conviction.